So welcome you all in this preparation for patent as an examination. So we have covered most of the sections. So today we are going to discuss on section 133 and 139, international arrangements. So in these slides, I'm going to talk very briefly on what are the topics covered. But again and again, I would request that please read the sections as it is. Sometimes we can discuss sections as it is reading from line by line, but that would take, more time for our discussion. Therefore, we are not going that way. Rather, I have worked extra to prepare these slides for you, so that it is always useful for you, especially during the time before the exams. You can quickly refer to these notes, and these are going to help you. Okay, so section 133. So section 133 is regarding the convention countries. So what it says that any country which is a party to an international convention or arrangement to which India is also signatory. Okay, so those comes in convention country. So and what is the other condition? Grants citizens of India similar privileges as are granted to their own citizens. So they should also reciprocate in the same way. Then only they will call as convention countries. So there has to be party to the international conventions, and where India is also signatory. And the most important part is that there should be equal reciprocation from their side. I mean, if a person from India files a patent in their country, they should provide equal protection as they are providing to their own citizens. Say they should not discriminate between my citizens and their Indian citizens. Then in that condition, any citizen of their country, if they file in India, then we will also provide the similar. So this is called convention countries. Shall be a convention country. Okay. Section 134, notification as to countries not providing for reciprocity. So as I discussed, so if they're not reciprocating, then we can always report back. So if any country does not reciprocate by providing similar rights to Indian citizens and what they are providing to their citizens, then no national of such country is entitled. Then Indian Patent Office will also not give them equal chances. So what they cannot do, such citizens from such country they cannot apply for a patent or register as proprietor of patent or register as assignee or apply for license or hold any license under a patent granted under this act. So meaning they cannot file patent, they cannot be a co-assignee. Means if I'm working in this country and my friend is working in other country and we collaborate, and then we want to have one patent with both of our names there. So they cannot be my name because his country is not reciprocating. So this comes under section 134. Very simple one. Then 135, convention application. So very simple one. Patent filed in convention country. This is called the basic application. So whenever they call basic application, so if a patent is filed in any country, the first patent, that is called the basic application. And then within 12 months, we need to make application for patent in India. Okay. And priority date of a claim for complete specification being the claim based on matter disclosed in basic application. So when you file the first patent, the basic patent in any convention countries, then when you are coming to India, when you are filing again in India, then all the claims should be based upon the basic application, then only you will get the priority date of basic application. If we introduce any new claim or new anything new in India, then we are going to lose that priority date. So this is similar as we discussed regarding priority date. So for more than one application for patent in 2 or more convention countries, the period of 12 months is counted from earliest filing date. So meaning, say for example, if China, Japan, US, and European, they are under convention countries. So if you file a patent, you file on in Japan on the January 1st, then on the 1st of February you file in US, then on March you file in some Germany, and then you came to India. So the priority date will be counted from the earliest filing date. Okay, so you cannot say that before coming to India I file in US and come to India, but then they are going to track how those priority has been cited. So whenever we open a patent, we can see lots of priority dates are there, and priority countries are mentioned there, and we can see the corresponding dates out there. For application made in 2 or more countries, then within 12 months, a single convention application can be filed. Okay, so first 135.1 says about the priority dates. So earliest the priority date, simple one. Second one, it says if you file more than 2 applications in 2 or more countries within 12 months, and then a single convention can be filed. Okay, a time of 12 months is counted from earliest filing date. Okay, so you can combine them both while filing, but the fee payable for making such application is equal to number of application combined. So if you file one application in India, so if you're paying some fees, then if you're going to combine 2 applications and file one patent, then you need to pay double fees, means it is equivalent to filing 2 patent, because you are going to combine both the patent, and you are filing a single convention application in India, but you will have to file double fee. Number 3 says for PCT application designating India and claiming priority from previously filed application in India. Okay, the previously filed application in India will be counted as basic application. Here the request for examination under section 11B shall be made for only one of such applications in India. Okay, so for example, you file in India and then you enter through PCT route, and again you through PCT route you enter in India, then you can file examination for only one. Either you apply for examination for this basic patent that you file in India, or for that which you have designated India. And so very simple, very logical, why Indian Patent Office will examine 2 patent application or everything same twice. So they will do only once, and you can say we can choose which one to do. Section 136. Okay, section 136 is regarding special provisions relating to convention applications. What are these? All convention applications shall, okay, accompanied by a complete specification, that is true, and specify a date on which and the convention country in which application for protection, as the case may be, first of such application was made. So all convention applications should mention a date, a specific date. Means if you filed first in China, you have to mention that first application, when the first application was made, that date and that country name has to be mentioned, and you need to file a complete specification. So here you cannot file a provisional application here. So provisional application is only applicable when you are an Indian citizen and you are filing in India. But if you are coming to through convention route, you cannot say that I am working in China and then I am filing a provisional application in India. So that is not there. It has to be accompanied by a complete specification. So complete specification means it has to have claims, description, and all the parts. State that no application for protection in respect and mention has been made in convention country before that date by any applicant. And you have to make a statement that based on your good knowledge, you have not made any application prior to this date. So as we have seen in section 64 regarding the revocations. So if you can identify that the patent application which you want to revoke has mentioned that first application was filed in China on January 1st, okay, but through your research, if you find out that no, first they filed in Japan and then they came to China and then from China they came to India. So if you can find out that those things, those information, then that could be a ground for the revocations. A convention application may include. So can anyone state which is that number? I just want to check your preparation level. 64. I'm also opening. You also open. Which is that under 64 says that it can be revoked. Section 64. Which is that number? Just looking at that number. Which is that number? Did anyone get it?
Sir, question क्या है sir?
The question is that in case of convention applications, okay, if you do not mention the priority date properly, then it can be revoked.
Okay.
Okay, so a convention application may include claims in respect of development of or addition to the convention in which the application for protection was made in a convention country, being development or addition in respect of which the applicant would be entitled under the provisions of section 6 to make a separate application for patent. So if it is any improvement, he's entitled to make separate application under provision of section 6. What is section 6? Can anyone tell quickly?
Person entitled to apply for patent.
What it says? Subject to the provisions contained in section 134, an application for a patent for invention may be made by any of the following person, that is to say, by any person claiming to the true and first inventors of the invention. So under section 134, you can find a patent application. Okay. Next one. Number 3, a convention application cannot be post-dated under subsection 17. What is subsection 17? What is 17? What 17?
Power of
Power
controller.
to make
Power of
orders
controller to dating of
respecting
application.
dating of application.
Dating of a patent.
And how much post-dating can be done? Not later
Not
than 6
later
months.
than 6 months.
Yeah.
From-
So this kind of dating, post-dating cannot be done for the convention applications. Next is multiple priorities. Okay, where 2 or more applications for a patent in respect of invention have been made in 1 more convention countries, and if inventions are related, then a combined application can be filed within 12 months. Section 135(1). Okay, so section 135(1) it says that we can combine. Okay, 12 months counted from the earliest filing date. Okay, then you will have multiple priorities. The priority dates of a claim of complete specification being a claim based on matter disclosed in one or more of the basic application. Basic application means the first file applications is called basic applications, is the date on which the matter was first disclosed. So what it says that where two or more application for a patent. So you have made separate applications. Okay, now you want to combine together, and then all these separate applications are called basic applications, and within 12 months you can combine them together. Okay, but when you make a claim references, so the claims, so if you file one claim in January, one in March, one in December, so depending on when that claim and that basic application was filed, so while checking the validity of that claim, reference to that application will be made. I mean, some claim may not have 12 months time. So some claim may have 10 months time, some claim may have 1 month time only. Okay, so depending on that when it was filed, but within 12 months we can combine them together. Okay, so 12 months will be counted based on the first application. So if you file first application on January, second application you filed on June, third application you filed in December, and then the third applications, if you are going to combine the first application filed in January, then the December application, okay, this application, and if you have a claim based on December application, for example, in January you filed something on copper, in June you filed something on gold, and then in December you filed something on silver. Now you want to combine together and you say that we claim copper, gold, and silver together in some claims, maybe independent claims or dependent claims. But while checking the priority dates of those claims, so I mean, it will depend on when the application was filed, not the earliest one. But 12 months will be counted from the earliest one. So this is the meaning. So when 3 applications are filed, you can combine these 3 applications. So whenever you read a patent, you can see the priority dates. So sometimes they mention 1 application, sometimes they mention 2, 3, or 4 applications. So these are mentioned. Okay. So this is the meaning. A matter shall be deemed to have been disclosed in basic application for protection in a convention country if it was claimed or disclosed otherwise than by way of disclaimer or acknowledgement. Okay, in that application or any document submitted by applicant, a copy of the document needs to be filed at patent office with convention countries. Okay, so this is important. So all the document that we submitted, that has to be filed in the patent office. Okay, then only it will be considered as a part of a specification, and you can, based on those, you can form the claims. 138 is supplementary provision as to convention applications. So some few extra things. A copy of a specification or documents filed at convention country needs to be submitted if controller asks for it. Translation into English or a specification of documents verified by affidavit shall be provided when controller asks. So if it is in different language, then translation has to submit it. And date of filing is the date on which is mentioned in certificate of the official chief of the patent office. So each country can have a seal. So that would be considered as a date of filing. For PCT designated India for application under section 7, 54 and 135. What is section 7? Section 7 is, can you tell quickly? What is section 7?
Form for application.
Form of application. So what is
Form
there?
of application.
What it contains? It talks about provisional and complete specification, or what? What it says in form application, section 7? What it says?
Every application for a patent shall be made in the prescribed form for one invention only.
Correct. And what is section 54?
Patent of addition.
Correct. And what is section 135? Convention application.
Convention application.
So for PCT designated India for application under section 7, 54, 135, title, description, claim and abstract and drawings. Filing international application shall be taken as complete specification. So if it is coming through PCT route, so whatever is filed in the PCT, so that will be considered as the complete specification. Therefore, if you are looking at any application that has been filed in India, but if it comes through PCT route, so I see variations in different applications. Okay, so this is the meaning, because likely what has been filed in PCT route in that is considered as a complete specification. But when application is filed directly to India, then that those are different. You will see some differences, meaning the style of writing and the way of presentation all varies. Filing date is the international filing date under PCT. So when you file the PCT, that will be considered as filing date. Okay. Amendment, if any proposed by applicant for an international application designating India, spelling galat ho gaya. India, okay, IN, this is mistake, India, or designating and electing India before international search authority or preliminary examination authority shall, if applicants so desires, be taken as amendment made before the patent office. So before such authority, if you make those amendment, then it will be taken as the amendment made before the patent office. So very simple, nothing much complicated. So many things in these sections are mostly practical one, and you can remember for the exam purpose based on like previous understanding regarding priority date. So always the earliest on the priority date, and again regarding the combining of the multiple applications, so you can combine together. Yes, you can combine application. So mostly what I see, what kind of questions are asked in here is mostly true and false kind of questions I have seen that are asked. Okay, and in interview, I have understanding that sometimes they asked how the PCT applications are filed. So maybe sometimes before the examinations, if we plan to have any sessions, that time I will discuss this PCT route of filing application. What are the steps? What are the forms I fill? Because those are not covered in our current sessions. Okay, so this time we cover form 1, 2, 3, and all those forms and rules I have covered. But for PCT route, if you're someone coming, then what are the steps are taken? Those things I have not covered. This is not difficult, but I have not covered it. So we can discuss sometimes before the examination if you meet to discuss. Section 139, other provisions of Act to apply to convention applications. So patent file under PCT or as convention, all provisions of this Act shall apply, and a patent granted is same as any ordinary patent granted. So this is same. This is called the reciprocity. So India, anyone coming from China, Japan, US, Europe, or any other convention countries to India. So as the rights are granted to Indian citizens filing patent in India, same rights and everything to them also. Okay. So this is the simple meaning. Okay. So with this, we have completed the session. I will stop it here.